Bob Kerrigan for Kerrigan, Estess, Rankin, McLeod, and Thompson. Today we're going to talk about comparative fault. What is comparative fault? Because it may apply to your accident or case in which you're involved with now. Many, many years ago, I tried a case against one of the older trial lawyers in our community. His name was Joe Harrell. He's a wonderful lawyer. And we had a case in which the following facts were relevant. My client, I thought, was 100% faultless because she was going through a green light. She was hit by a truck, a big truck that went through a red light, but was visible well down the road, and you could see the truck coming. Well, I thought, this is a slam dunk. How can I lose a case like this? Well, I didn't lose it, but here's what happened with comparative fault. The jury found 75% of the fault on the truck, but 25% on my client, because this great old trial lawyer said she should have seen a big truck coming and slowed even though that truck was running a red light. That's called comparative fault, and that's how it works in Florida, is that you compare the fault of each party. So many times people will call us and say, well, I was cited with a ticket for the accident, and they don't think they have a claim. We do the investigation, and we sometimes determine that, well, although the ticket might have been given to you, there's a good deal of fault on the other driver because of X, Y, or Z, and so we take the claim. Or if we do a thorough investigation and determine there's no fault on the other driver, we tell the people that they will not have a claim. But they may have a claim because of comparative fault. Now, years ago, in some states where they had what was called contributory negligence, it worked this way. If you were involved in an accident and you were 1% at fault, 1% at fault, you made no recovery at all. And the way the defense lawyers always argued it, they'd hold up a piece of paper like this and they'd tell the jury, assume this is 100% of the fault right here, of the fault of the accident. And then they take a little piece of paper like this and they say, if you find this much fault on the plaintiff, the person that's bringing the claim, they can't recover a dime. Well, you can imagine how unfair that was. And practically juries would go back and they'd say, well, that's pretty harsh. So they would make an award that they thought was fair under the circumstances. But the strict application of the law, which still is true in some states, is that contributory negligence, a tiny, tiny percent, bars you completely from making a recovery. In Florida, it's allocated among the parties. We had a case not too long ago where a young woman was hit and struck by a vehicle, and the jury found because of her clothing, and it was at night and in the road, that she was 55% responsible, so our recovery was limited. So if you have $1 million claim and the jury determines that you're 55% at fault and the other party is 45% at fault, you would recover 45% of $1 million or $450,000. That's called comparative fault. And there's one other little wrinkle to this. I talked about contributory negligence, but in some states like Georgia, by the way, Alabama was a contributory negligence state, it still is a contributory negligence state. Georgia, the law in Georgia is that if the person who's injured is more than 50% at fault, they can't make any recovery at all. That's Georgia law. Florida is what they call pure comparative fault. So if you're 75% responsible and you're paralyzed in an accident, you still can make a very substantial recovery because of comparative fault. We'd be happy to analyze and look at any case that you may have or think you may have without any obligation and without any cost, or you can consult our website, Kerrigan.com, Kerrigan.com, and thank you for watching.